In the first couple of hours of that interview, you kept saying that there was one shooter, true?
Yes, I did.
You said BJ was shooting, correct?
Yes, I did. I said a couple stuff. I was shook up. I was scared. I didn't know what to say. I never been in no situation like that before.
And we are back, and we are back. Go ahead and hit that like button for us. You already know it helps us out, and it helps you because it helps us. Now, we have a video here. First, we're going to get into a bunch of motions back and forth about evidence as usual. So y'all sit tight for that because you know the evidence is of the utmost importance in this trial. You have DA Love back. You have DA Love back arguing. So if you missed your love, well, you're going to get a healthy dose of Love's arguments today. And then we're going to see Miss Angela DeWilliams. We're going to see her get into her attorney business with an accuser of her client, of Mr. Williams' client, Lil Rod. And as you're going to see, the witness says that she lied on Lil Rod. So I'm not going to do a lot of talking. Without further ado, sit back, relax, and let's get into it.
Confrontation clause or convictions of one defendant is that we give a limiting instruction, Your Honor. And so I would say that a limiting instruction and given 24-803-22 would suffice to allow us to introduce the certified conviction for Rodelius Ryan's murder. And I hope that I have not come in too fast and made no sense to the court.
Now I follow you. Okay, well, when I get the limiting instruction from the state, I'll take a look at that and the one submitted by Mr. Steele, because clearly that's what needs to be correct, because it's a complicated situation here. Does anybody else want to be heard on that issue?
Trying to get on my Lexus to see the statue. I'm having a little connectivity, slow internet issue.
It's slow, all right.
I thought I was waiting on the court. Your Honor, and I did as you ordered, requested, or suggested, whatever. And I worked on it a lot, and I hope it's helpful to the court. But I'd also like the court to take note. I think that everyone agrees on the law, so I'm not going into it is a confrontation clause violation if there's no way that this court is convinced that the jurors will limit the use against the person who tendered the plea or the verdict was reached. But I ask you to consider also Henderson, H-E-N-D-E-R-S-O-N versus State. It's 317 Georgia 66. Your Honor, it's in Division 4A is in Elisa. That's 891 Southeast 2D 884. It's 2023 case. And what it talks about, it's a Bruton issue. Mm-hmm. And it's the U.S. Supreme Court just came out with the newest Bruton case last year. And the issue in Bruton is what used to happen is the court, and I'm very familiar with the court's background. The court probably knows all this, but it used to be a limiting instruction. So a person gives a statement, there's a limiting instruction. And then the court said, yes, jurors are presumed to follow the court's instruction, and jurors under oath are deemed or presumed to follow the rules. But the court said, sometimes it's just too much. So what happened then is Bruton became the rule that now we're going to redact any mention, direct mention, it could be influential, but any direct mention of another person on trial from the non-testifying co-indictee on trial's statement. So, testimonial statement. And here, that was my struggle the whole time. It's not as simple as this statement can only be used against a person, because this is deliberation time. And it's an overt act. Mr. Ryan's case that the court is entertaining right now and permitting to go forward is an overt act. And what you're going to say, I believe, is that if the state proves beyond a reasonable doubt that an individual, I'll just use Mr. Williams, willfully and knowingly joined a conspiracy with others, one or more, then all of the conduct of anyone in that conspiracy can be used against Mr. Williams. But here, you're going to have to, and that was my struggle, say, but not this overt act. So this overt act gets separated. And I know I've asked, and I believe the court is entertaining separate verdict forms for everyone. So that will assist. I said you could remove that overt act from a verdict form. But it's the deliberation. So the jurors presumably go back and deliberate. I'm just using Mr. Ryan's name because it's on the issue here. And they're talking about what's going on now in these several days of testimony. And then they're going to hear potentially the jury verdict. And then the jurors will be deliberating Mr. Williams and say, God forbid, he's part of the conspiracy. And then somebody's going to have to say, but now we can't use that verdict of that other jury, so let's erase that from our blackboard or our notes or deliberations. And I think that that gets complicated. Then you're going to have the same issue with Mr. Kendrick. And, Your Honor, the predecessor judge denied our objections to this evidence, gave no limiting instruction, said he would deal with that later. He understood it was an issue, but deal with it later. And Mr. Stillwell's guilty plea, or pleas, I believe that there are several, have come in without any type of instruction yet. So that is going to have to be dealt with. And Mr. Nichols has at least one guilty plea, maybe more, but I believe one guilty plea. That has come in the same way over the objection of timely objection, and the predecessor court stated that it would be dealt with later. So I don't believe at this point in time where we are, I tried my best. I did this several times. I gave you what I think is fair to everyone. I tried to be fair to Mr. Ryan and Mr. Kendrick in the instruction, but I don't believe, like in Bruton, I believe at some point it's just asking too much. That's what. So my objection is to admit the evidence since we're in a joint trial. Now, typically it's a severance. Severance would do it away, but, you know, that's in the breast of this honorable court, but I'm not looking for a severance. I mean, personally, I'm just telling, I don't want to leave this jury right now. That's my issue.
Okay, so what you sent me, and I appreciate that, is about Mr. Kendrick's guilty, oh, I see, so.
I merged them, and I
It's the
understand it's now
same.
Mr. Ryan, so you're going to have to, if you like it or use
Okay.
any part of it, you're going to have to flip it.
Okay.
But I just gave both.
All right, and when do we expect, if it comes in, the trial conviction of Mr. Ryan to come in?
Your Honor, it may come in today, but if the court will permit, I'd like to also address something that I just heard said that I think is important with respect to the use of these overt acts against the other defendants. There's nothing in the law that supports the proscription on the use of those overt acts. In other words, like I said earlier, if it's an overt act that has been committed by someone else, there's nothing, even if it's a co-defendant who's not testifying.
But, I mean, I think the problem there is our confrontation clause problem. How do you get around that?
Your Honor, the same way, and we did also submit to the court a brief.
Well, I haven't gotten any of what you submitted. I don't know where it is in the ether, but maybe y'all could send that again.
Okay, we submitted a brief on overt acts. And
That I do have, yes.
okay, and that partially is addressed here, but previously with respect to the confrontation clause, in the same way that when we dealt with a statement given to the police by a non-testifying co-defendant, Your Honor, the courts have been clear that a limiting instruction is what is necessary. So if we are approving.
That's a whole lot different, though, than, I mean, I hear you saying that the fact of Mr. Ryan's conviction of murder is something that can be introduced against and used against as an overt act all of these co-defendants, despite the fact that as to them, they weren't parties at that trial and so never got to cross-examine any of the evidence that is what resulted in Mr. Ryan's conviction. So how do you get around, that's a clear confrontation clause issue. How do you get around that and just be able to say, oh yeah, no, that can be considered against them as well in this trial?
Your Honor, I guess I would analogize it to, say, for instance, the posting by, I'll use, for instance, Diamante Kendrick of his picture saying Maniac is back on January 10th after Donovan Thomas is killed, right? So no one can cross-examine can cross-examine Diamante Kendrick.
But that's a statement by a co-conspirator.
Or the statement that Diamante Kendrick gave the police, or the statement that Shannon Stillwell gave the police, or any other piece of evidence. The point that I'm making is that evidence that is used to prove an overt act, which does not even have to be a crime. So
I understand that. Let's not go down that. Let's focus on the issues at hand.
evidence that is used to prove an overt act can be used against, in this case, under 803.22 or 24.803.22 can be used against Mr. Ryan, can be attributed to him.
Sure. Nobody, I don't think, disputes that.
Right.
That it can be used against Mr. Ryan.
Right.
I thought you were saying you think it can be used against everybody else, despite the fact that it's a conviction. If used to prove anything against anybody other than the person convicted is testimonial, and therefore presents us with a confrontation clause issue.
No, what I was saying was that it constitutes an overt act committed by Mr. Ryan. And an overt act does not have to be committed by...
I know, but how are you getting around confrontation clause?
Because it's not, there's nothing for either of them to confront. It's an act that was committed by, if we use nothing else.
No. Okay. So if you just, in this trial, reprove that he committed murder, although then the jury has to make that determination, then sure, that evidence, everybody gets to confront whatever evidence you present here. It can be used against everybody. If you say, here's a certified copy of Mr. Ryan's jury trial conviction for murder, none of the other co-defendants got to confront the evidence that resulted in that conviction. So that's what makes it testimonial. It's here's the conviction. Here is this fact. It is established. And no one got to confront that other than Mr. Ryan, of course. So it's not, it's the conviction. It's here's another jury saying this is a fact. So if you don't use that, then whatever you use to prove it here, sure, that can be used against everybody because they all get to confront your evidence here in this trial where they are parties. Do you see the difference?
Your Honor, I do.
Okay.
To a very large extent, and I'm in line with the court for the most part. I'm having a problem, and I hope that the court forgives me for that. With that last portion, the idea that it's a piece of evidence that they can't confront, and therefore the whole act can't be used against.
It's a finding by another jury of fact that they haven't been able to confront. So
if
how do you get around the confrontation clause issue? Yes, sir. And
I'm sorry.
is somebody going to send me what you proposed as a limiter?
I'll send it again.
Okay.
And I apologize. I know I walked in.
Okay, it came through. Thank you. Yep. All right.
I just
Yes,
want to make
sir.
sure I'm hearing the court correctly, so we're all on the same page. So as it relates to the certified conviction, the limiting instruction would just relate to just that. But the evidence that we've presented here in court as it relates to the murder that Mr. Ryan and Mr. Blaylock were convicted of, the evidence that's been presented here in court today, we can argue that as it relates to all the defendants, correct?
That would be my position.
Okay.
I mean, don't know that anybody can argue against that. Now's your chance.
Well, I would like to.
But yeah, I mean, yeah, so yes, that is, everybody accepts that as the law, even if they don't like it.
And so, Your Honor, if much in the same way that there is a piece, for instance, someone admitted that they committed a crime, like Mr. Kendrick admitted that he and Mr. Arnold were going to go retaliate against a rival gang member. Say that piece, that fact is something that they cannot confront, but the overt act that they actually were going to go committed, that we show evidence of, all of that evidence is admissible against everyone. But Mr. Kendrick's statement, which they cannot confront, which is establishing a fact that goes to prove this overt act, they cannot confront it. And the courts have held that even in a conspiracy case, under those circumstances, that statement can be used with the limiting instruction. That's why I began with the fact that it's analogous.
Okay, so I think we're all generally on the same page about that. It's what does the limiting instruction need to say?
That's what I.
All right, so yes.
I'm not on the same page.
Are you on the same page with what I'm saying?
I am. This is a little different in my mind. I thought I was on the same page, but that last statement, I'm not on the same page.
Well, that's not the issue we're facing anyway, so it doesn't really matter whether we're on the same page about that. Are you on the same page? I mean, what I have said so far, do you agree that that's the law?
Yes.
Okay.
I think the difference is, and I think Mr. Steele articulated this as well, is when you have a guilty plea that deals with an overt act, that is a little different than a statement as part of the overt act, and it makes the ability to draft a limiting instruction that is workable exponentially higher.
I agree.
Okay, all right.
I agree. That's why I've been asking y'all basically since I took over this case to come up with something so that we could have something to work on. But of course, I'm getting it the day that the evidence is coming in, which frankly, it is not going to be able to come in before lunch because I'm not going to have time to sit and try to put it all together before lunch.
And
So,
Your Honor, if I may, we don't have to even introduce that today. We can introduce that whenever the court tells us that, we've had enough time to litigate it.
Okay. I appreciate that. All right. With regard to the Looney Lee evidence, were y'all able to sort out the rest of that? I don't know if there was anything left over from last night. I think maybe there were a couple of things you were still looking at.
Yes, Your Honor. So I need, and what I was going to do right now is there's a 10-page PDF that the state has whittled down the Instagram threads that they would be intended on using. And so I think this should be able to be emailed to all parties. So I'm going to send it to everyone right now. And if someone's email doesn't receive it, just let me know.
Okay. So I'm looking now at the state's proposed limiting instruction, which is basically just like a version of our pattern limiter for things. And it's not particularly helpful because it doesn't address any of the nuances. So if there's any way y'all could beef that up to try to address the nuances of what it is we're dealing with, I would appreciate that. Mr. Harvey.
Yes, Judge. I spoke with Mr. Atkins yesterday with regard to some of the Winnie Lee Instagrams.
Okay.
and I don't know whether that was part of what he proposed to send everybody. Mr. Atkins?
Yes, Your Honor. And Mr. Harvey's correct. This has came up before where there's a Instagram handle that is, I believe, /QUA.
Okay.
And so Mr. Harvey was indicating that if that portion, which it is included, that thread in the reduced Wooney Lee Instagram, if that were to get introduced to discuss, to not either a stipulation or something for the jury that, to the state's knowledge, does not believe.
Well, that's fine. Do you'll have a
It is in
stipulation,
reference.
or will you have a stipulation by the time it comes in, if it's going to come in?
Yes, Your Honor, I would like to, and I think I'd have time to
Okay.
speak with Mr. Harvey and also probably Mr. Matthews about that.
All right.
That's right.
Great. Thank you.
All right, thank you.
I do have some objections to some of the Wooney Lee exhibits. Specifically, there's two. There's a picture of my client wearing a trench coat, a denim trench coat, and it's a post, presumably by, yes, OG Bull is the post is under, and it says, "Ain't none more compatible than a trench, a carbon, while in the trenches," and then some hashtags, Freequay, NSLB, 2Bs, life size, and it says booking riches on the way. I get that these are allegedly my client's statements. They're statements by a party opponent to deal with the hearsay issues. However, in my time trying cases, the way I've always thought of it is if there's a picture, say, and there's no picture of a gun here, but I'm just using that as an analogy. If there's a picture of a gun with my client on social media, which there's no pictures of guns with Shannon, you would have to tie it to a specific crime. Otherwise, it's just bad character evidence, would have limited probative value, and it would be excluded, presumably, or my argument would be excluded under 403. This is from September 18, 2020. My client's charged with a murder in 2015. He's charged with a murder in 2022. So this is not close in time to any acts of violence that my client's alleged to have committed. And I acknowledge that ain't none more compatible than a trench, a carbon, while in the trenches could be viewed as a reference to a firearm. I'm not denying that. But what's the purpose, and is it anything more than just bad character evidence that suggests my client's around firearms? I just don't see any connection to any of the allegations in this case. So that's the first objection.
All right.
And then I have one more.
What's the state's response? In what item of evidence is that?
It is in the Dropbox. I'm sorry.
Okay.
If you could help me out on that, what folder it's in.
I am pulling that up right now, Your Honor, to orient both defense counsel in the court. It should be in the two drop boxes where evidence for Wooney Lee was sent was the co-conspirator larger drop box and also the witnesses 31 through
The
60.
one that says Wooney Lee social media. Is this Instagram or what is this?
I believe it's in the Viverito folder, perhaps in the Jamari Holmes case.
Does somebody want to just put it on Zoom for me? That might be easier.
Yes, Your Honor. I will log into Zoom.
Okay, and then I'll need to hear the state's response. I need to log into Zoom also.
Yes, Your Honor.
Or no, I'm already
I'm gonna,
there.
if the court permits, pull it up first and then.
Sure. Is it Instagram or what is it?
to be clear, Your Honor, it is an overact listed in an indictment, but from my perspective, that doesn't change the analysis. Just because the state alleges is an overact, if they allege an overact, a post that would fail 403 analysis, I don't believe that automatically makes it admissible, just because they chose to plead it that way. They don't get to plead their way out of the rules of evidence.
Your Honor, it is Act 115. Overt acts do not have to be crimes in and of themselves. I am
Betty knows that.
pulling up the Zoom now, Your Honor. So, Your Honor, if the court likes, the state can make argument, but the state feels that, whether this is an overt act or not an overt act. Oh, sorry, Your Honor.
Okay, go ahead.
Yes, Your Honor. Whether this post furthers the conspiracy or not is what the parties respectfully will be arguing to the jury. And so when and if this Instagram post gets admitted, the state has to connect it and prove to the jury that it's an overt act in terms of the conspiracy, and defense counsel, of course, can cross and argue that it's not. And so the state doesn't feel that the state at this time, unless this court wants more argument, feels that overt acts do not have to be crimes. This is Act 115. The state is alleging that this public Instagram post referencing firearms, he says in the trenches, but having firearms is something that is an overt act of the conspiracy.
All right, I'm going to overrule the 403 objection on that. What's the next one?
Excuse me, can I make sure that I preserve 801D2E with regard, an 801D2E objection with regard to that particular statement?
All right, well, that's overruled as well, but preserved.
Thank you.
The other one, Your Honor, is it's a verse from a song performed, a very good song by my client, and it was, and this has been litigated, full disclosure, but I just want Your Honor to understand the argument because it was litigated in front of the prior judge. Mr. Stillwell in his song says, "I beat a murder rap." He was on bond. He requested a speedy trial. There was all sorts of things. He ends up on bond. It's been years since he's been arrested. He says, "I beat a murder rap, paid my lawyer $30 for that." I don't know how much he paid. It wasn't me. But somehow, when we litigated it before, "I beat a murder rap" was deemed an admission. Like, I don't know. I've asked a lot of people this. When you say "I beat a murder rap," and universally, I figured maybe it's just me that I'm analyzing it wrong. Universally, everyone said to me, "No, it just means you were charged and you beat it. It's not saying that you did it and
I agree
you beat
with
it."
that.
Well, I don't know how that's an admission.
Okay, well, the jury hadn't been told it's an admission, have they?
Well, why is it admissible then? If it's not an admission, it's just a song saying, I was arrested.
It's an admission in evidentiary terms, like an admission by a party opponent. It is not, I would not view it necessarily as an admission that I committed murder and then got away with it. But that's not what we mean evidentially when we say it's admissible under the rules of evidence as an admission. It's an admission by a party opponent, which it is that. So.
Except when we've been dealing with lyrics, and these are lyrics, we've been cognizant of First Amendment.
Yes, and everybody gets a right to say whatever they want, within the bounds of the First Amendment. But if that is also something that might be able to incriminate them in some manner, then, that's the choice they made.
Okay. Well, I would just like to reiterate my objection under relevance in 403 because
All right,
historically saying I was arrested and I beat it, I just don't see the relevance of that. But I understand the court's ruling.
Okay. What else?
That's all.
Okay. So was there a second Wooney Lee item?
Your Honor, I think we just addressed at least the two that Mr. Sharp.
Okay. There weren't any that Mr. Ryan had issue with.
I will not speak for, they may have issue with the reduced, I just sent to the parties
He just sent it.
5
minutes ago.
It's so that they may have objections to what the state wants to.
All right. When are we going to be getting to it?
I personally think he would come up tomorrow. He could technically come up today, Your Honor.
Okay. So look at it over the lunch hour.
Yes, Your Honor.
Or now, if you can. But all right. Let's just make sure that we circle back on that before.
And yes, we will have objections.
Okay.
It's only 10 pages, though, so it shouldn't take too long.
All right. Are we ready for the jury then? No. We have a juror who is late but should be here very shortly.
I think also, Judge, there were 2 additions to the state's.
Oh, yes, thank you. So there were a couple of witnesses that y'all were asking not be shown. And those are additional witnesses, right? Let me find my.
Your Honor, we addressed the court. We addressed, Mr. Harvey and myself were at the bench, the 3 witnesses the state had requested.
Right.
And so I believe that in terms of who should be shown.
Y'all sent an email, last night? Asking, this was Ms. Hilton, about last name Coppage and last name Henderson,
That's correct, Judge.
not be filmed?
That was sent.
With respect.
So they're both on the witness list already for this week. You're just asking consideration be given that they also not be filmed.
Yes, Your Honor. And I don't believe that either of those witnesses will be, I know they won't be before lunch. They may not be before the end of today. As a matter of fact, there's a 99% chance they won't be before the end of today.
Okay, and y'all all have the email, right, that provides the rationale?
Yes, Your Honor. We do have the email.
Anybody gonna object to them not being filmed?
Well, I'm going to generally object. However, I'd like to get some clarification from the prosecution regarding the coppage from the information that was presented in the email.
All right, why don't we do that at the bench?
Okay.
Y'all come on up. We've got somebody for everybody now. All right, in the few minutes that we had the recess, I have been taking a very preliminary first stab at the jury instruction that Mr. Steele begrudgingly provided the court to work on. And I am going to send that to Ms. Persifield to email out to all of y'all. And I would like for anybody who wants to, including, I'm going to require the state to take a look at the jury instruction as preliminarily modified by the court from Mr. Steele and really try to work on the nuance of what it is that the jury needs to understand. And I'm not sure that. Okay. Mr. Steele, your instruction was going to tell the jury you can't consider either the guilty plea of Mr. Kendrick or the jury conviction of Mr. Ryan in any way in determining whether anybody else is guilty, basically, of the RICO count. And so that's the difficult part that we need to parse out and be able to explain well, because this is evidence that Mr. Kendrick committed that particular overt act, and it is evidence that Mr. Ryan committed that particular overt act. That's a fact. How that can be used, if at all, in considering anybody else's RICO count is what we need to be specific and correct in explaining to the jury. And so I need y'all to take a look at, what it is right now and try to get that crystallized for me.
Your Honor, when the court asked me to make it more specific and nuanced, that's what I was sitting here working on. So if the court wants me to not work individually and work from the one that the court sent,
I'll send it to you. If you find it to be helpful, work on that. If you want to send yours separately as well, and that's great. And I'll just try to take the best of all of them and put it all together. But I'd really appreciate y'all's assistance on those. And believe me, this is not anywhere near in final form. It's just what I had a chance to do in the last few minutes. All right, I think we are ready for the jury. So
Can I
if we
make
want
one-
to,
Oh, I apologize, Miss.
No, go ahead.
No. Ms. Abbasi stood up.
If Your Honor will allow, I will be asking at some portion to have a few minutes just to speak with a potential witness of the state. He did not appear yesterday because he was in custody. He was brought over today, and the sheriff's office is trying to locate him. So I've not had access to him.
Okay.
I will need a few minutes.
Okay. What's our order going to be after Ms. Smith?
Your Honor, I think that it would be about the third witness down that Ms. Abbasi wants to speak to.
Kind of let me know, and hopefully that'll align with one of our breaks anyway. Okay, so reminder that this next witness, Ms. Smith, is not to be filmed, and y'all be careful when you focus on the video boards too. So let's get her in, and then we'll get the jury in.
Your Honor, can I just
I'm
make
sorry,
one
wait.
more?
I'm sorry, Mr. Steele, you had something also.
Just for your hopeful put on your thought process, I also believe, though, that Mr. Kendrick's guilty plea to the gang involvement, he pled to a gang count, that's what we're dealing with now. Mr. Kendrick and Mr. Williams are indicted in counts, I'm going to tell you 56, 57, 58. I may be wrong on the numbers. Together. And that guilty plea, it's not only for the RICO overt act, but it also goes to those counts too, because I don't want the jurors to use, well, Mr. Kendrick admitted through a guilty plea that he was part of a criminal street gang YSL. So that has to be
Did he
incorporated.
actually admit it was YSL?
Yes, that's part of the
They're
issue.
going to know that from what they get presented?
I don't think we did not list YSL in the indictment on that previous indictment.
Right.
I think you did.
No, I just looked at the indictment. It doesn't say YSL in the indictment.
Okay, well, that's better. I did not.
Okay.
Memory's different, but if you looked, then I'm wrong, I'm sure.
Yeah, I just looked like 2 seconds ago. So it's not. It may be in the guilty plea transcript, but that's not going to them anyway. Okay. Let's get the witness and then the jury. We can be doing both at the same time.
Good morning, Ms. Smith. Okay. So yesterday on Direct, you said that you used to hang out at Bolly's house?
Excuse me?
Yesterday on Direct, you said you used to hang out at Bolly's house?
Correct.
And you used to hang out on the 3rd floor?
It was everywhere, all over the house.
Okay, so you used to hang out on the bottom floor, the main
All
house?
over the house.
And so it's a 3-story house?
I'm not sure.
You're not sure? Okay. And there's a door on the 3rd floor, right?
I'm not sure. I really don't remember.
Okay. The mom walked out of the door when she was on the 3rd floor?
I'm not sure. I don't remember.
Okay. So you testified on direct that when you went outside that night, you got into BJ's car, right?
Correct.
And then he drove you, Tahira, Red, Jamari across the street?
Yes.
Because Tahira told you that there's a weed man over there?
Yes.
And then when the car stopped, Tahira got out the car to go buy some weed?
Yes.
And then she came back and got you and told you somebody wants to talk to you.
Correct.
And you're not familiar with that area.
No, I'm
You
not.
don't know anybody there.
No, I don't.
So you got out the car to go talk to somebody who you don't know in an unfamiliar area?
Yes, because I was scared. I didn't know what was finna go on.
Okay. And then that's when you say you saw Lil Rod and Bali running and shooting, right?
Yes.
Okay. I'm going to approach you with what was previously marked as State's Exhibit 11, November. Your Honor, may I approach? You may. You recognize this exhibit?
Yes.
So I'm going to hand you a copy of this exhibit. Here you go. And we're going to mark it as Defense Exhibit 1RR. I'm going to leave this with you. And I want you to mark where you saw Lil Rod with an R. Use the sticker and write an R and put it on the blue copy. And then I want you to get another sticker and mark where you saw Bali with a B using the sticker. And then with the third sticker, I want you to mark where the charger was stopped with a C. I'm going to get that from you, okay? Oh, use the sticker.
Write it on there.
Right, write the letters on the sticker. And then can you also put an M where you were hiding in the bushes?
The bush is right there. You can see it.
Can you put the sticker on there? And I'll move to admit this as Defense Exhibit 1, Romeo into evidence.
It's admitted.
So now we're going to move on to your police interview after you were picked up, okay? Now, on direct yesterday, you said that you and BJ were friends, right?
I knew him, yeah.
Since 5th grade?
Yeah.
And you also told the detective that BJ put a gun to your head that night, correct?
Yes.
And you told so many other stories that the detective asked you if you knew the difference between a truth and a lie.
Yes.
In the first couple of hours of that interview, you kept saying that there was one shooter, true?
Yes, I did.
You said BJ was shooting, correct?
Yes, I did. I said a couple stuff. I was shook up. I was scared. I didn't know what to say. I never been in no situation like that before.
Okay. And then towards the end of the police interview, Detective Hogan told you what he thought happened, right?
Correct.
And then after Detective Casey told you, this is the time for you to sing your ass off, because if not, you're going to find your ass in fucking jail with these fools, right?
Correct.
And that's when you started adopting Detective Hogan's version that there were two shooters.
Yes.
And then that's when you started saying that there was a big gun.
It's never no big guy.
Big gun.
A big gun?
Mm-hmm.
I don't remember.
And that's when you started putting Lil Rod in your story, correct?
Yes.
So let's fast forward to the previous hearing in September of 2021 when you provided testimony, okay?
Mm-hmm.
And that's the first time anybody ever heard about you being trapped on this bottom floor, correct?
No.
Who'd you tell?
I told the police.
You told Detective Hogan?
No, I told the police when they came to get me. Where I was, inside the house.
So you told them on the way to the police station that you were trapped in a house?
No, I told my mom over the phone.
You
That's
told
how
your mother?
Yes, that's how the police knew where I was.
Okay. And did Detective Hogan bring that up during your interview?
I'm not sure. I don't remember.
So would it refresh your memory to look at your prior testimony from your prior hearing?
Mm-hmm.
Okay. Your Honor, may I approach?
You may. That looks like a pretty big binder. Are you going to point her to something in particular? Okay.
I guess.
All right.
I'm not going to have her flipping around. Yeah. No.
That's good.
No. Okay. Would you go to page 866? And then to yourself, read lines 6 through 13.
To myself?
To yourself. And when you're done reading, you can just close the book or just look up. So I know that you're done.
I looked at it.
Did that refresh your memory?
Yes, it do.
So you never told anybody that you were trapped in that basement?
Yes, I did. I told you I told my mom.
Okay. And yesterday was the first time anybody heard about Bali attacking you, correct?
Correct.
You kept that secret for about, 2019, 20, 21, 22, like 5-6 years?
Correct.
And you would agree with me that you changed your past testimony several times about who had a gun that night?
No.
Okay. Would it refresh your memory to look at the transcript?
I mean, if you want to put it up, that's cool. I'll look at it and refresh my memory if that's what you want to do.
Okay. So let's start with where you said Lil Rod had a gun. Go to page 809.
Can y'all approach for just a second?
Did that refresh your memory? Mm-hmm. Okay. So you said Lil Rod had a gun, right?
Yes.
Okay. Then let's go to sorry. And you said that several times that he had a gun, right?
Both of them had guns.
Okay. But then you also testified you didn't see anybody shooting that night, correct? You have to say it for the record.
Yes.
Okay. And you also testified that you didn't see any guns that night, correct?
Mm-hmm.
Okay. And then also, while you were on that bottom floor, you just found a random phone?
Yeah, it was a phone at the house.
And there wasn't a passcode to get in the phone?
I don't remember, but I could call somebody, so apparently it wasn't.
But you didn't call 911 to let them know that you were trapped in this basement?
Nope, I called my grandma and my mom first. And by the time I called my mom, 911 was at her house.
And when you were on the phone with your grandmother and your mother, you told them, I just saw a shooting?
No, when I called my mama was yelling and screaming, telling me homicide at her door.
Court's indulgence. Your Honor, thank you.
All right, are there other defense attorneys with questions for this witness?
May I retrieve my...
Yes, certainly.
Thank you.
You're welcome. All right, is there redirect?
Very briefly, Judge.
Sure.
Good morning, Ms. Smith.
Good morning.
So, on cross, do you remember the defense counsel asking you about when you told the detectives at the beginning, when you started your interview, that you didn't see any guns or anybody shooting? You remember asking that question?
Yes, I lied a couple of times.
Okay. Can you tell the jury?
I'm sorry.
I'm sorry.
Sorry, is that better? Oh.
Not really. You may either have to pick it up or use the lapel mic.
All right, so let me start over. So do you remember defense counsel asking you on cross a few minutes ago, about at the beginning of your interview with the detectives, that you said that you didn't see anybody shooting and you didn't see any guns. Do you remember her asking you that?
Yes.
Okay. Can you tell the jurors why you said that at the beginning part of your interview when you were speaking with Detective Hogan and Detective Casey?
The reason I lied a couple of times was because I was shook up. I never been in no situation like that.
And can you tell the jurors or explain to them, when you say you were shook up, why were you so shook up?
Because, like, I was still around them. Like, during the situation, after they did what they did, I was still with them. I couldn't go nowhere until the police came.
When you say them, are you talking about Lil Rod, Bally, or Blaylock?
Yes.
And your friend, Ms. Brazy?
Yes.
And were you shook up because Ms. Brazy had set you and Jamari?
Objection, leading.
Overruled.
Were you shook up because Ms. Bracy had set you and the people in the blue Charger up?
Yes.
And did you know anything about the fact that she was going to do that?
No, I didn't.
Hold that mic closer to you, Mr. Body.
Sorry.
Thanks.
Now, Ms. Williams asked you, or she phrased her question after Detective Hogan told you something that you just adopted it. Is that what you did when you were speaking with the detective and you decided to tell the truth?
Yes.
Okay. And were you telling the truth, or were you just telling the detective exactly what he said?
I mean, I was telling some bit of the truth, but I was still lying.
Okay. And when you told the detective that you saw Little Rod and Bally run up and start shooting at the Charger, were you telling the truth?
Yes.
And can you tell the jury, based on, you said you had known BJ since, what, 5th grade?
Mm-hmm.
And in your interactions with BJ and Red and Jamari, can you tell the jurors, were they all pretty close friends?
I never knew
Speculation. Yesterday she said she didn't know him.
Overruled.
I don't. I knew BJ. I didn't know the rest of them.
Okay, so I'm gonna ask my question again, maybe be a little more clear. You remember you talked about yesterday, you got into the Charger, remember that?
Mm-hmm.
And when you were in the Charger, did you kind of witness and talk with and interact with BJ, Jamari, and Red in the car?
I can't really remember. I just know I was in the car with them.
Okay, and
But I know me and BJ had a conversation like about getting weed or whatever like that.
okay, and during the conversation and while you were in the car, was everybody interacting with each other, in a friendly way?
I mean, I really don't remember, to be honest.
Okay,
I just know the whole time Brazy was talking, leading him to the apartments. That's it.
and that's okay. Do you remember also during your interview with Detective Hogan, he asked you, we talked about yesterday, but he asked you about BJ's Instagram handle or user ID. Do you remember that?
Yes.
And do you remember what you told Detective Hogan BJ's Instagram user ID was?
Yes.
Okay, can you tell the jury?
I don't remember like exactly the name I told him, but I told him a name.
Okay, you remember telling him a name?
I do, but I don't.
Okay. Do you remember telling him that his Instagram handle was for Lil Joker?
Yes.
Okay. just have a few more questions. So when defense counsel asked you some additional questions about, as Detective Hogan and Detective Tracy were talking to you about what happened, do you remember that?
Mm-hmm.
Yes?
Yes.
Okay. And Ms. Williams asked you about whether you were just saying things because they had said it to you. Do you remember her asking you that?
Could you say it another way?
Let me ask you this. When you told Detective Hogan and Detective Tracy that you saw Little Rod and Bally shooting, was that because you saw it, or is that because they gave you some impression that they knew that they...
Objection leading.
Overruled.
I actually saw it because, for one, they never got in the car with us to know where we was going. For two, when we ran through the breezeway, I saw them shooting their guns at the car, literally.
And my last question is, back when this occurred, back in February of 2019, can you tell the jurors, how old were you back then?
I don't remember.
How old are you now again?
23.
Okay, and this was roughly 5 years ago? Yes? Your Honor, I have no further questions.
All right, any recross?
Just one, Your Honor.
Go ahead.
Did Lil Rod have the big gun?
I don't remember. I just know they both had guns.
That's it, thank you.
All right.
Can I go use the restroom, please?
It's not going to be much longer. Hang on just
Okay.
a second. I mean, no, is it something that came up in the redirect or recross?
Came up in the cross. And it also came up in direct.
Well, if it came up in direct, then you should have asked to cross. Go ahead.
I have just one or two questions for you.
Okay.
So BJ, that's the gentleman that you'd known for 5th grade or whatever, right? Okay. Is that a yes?
Yes.
Okay. BJ threatened you, right? BJ, and then after that threat was made, then your house was shot up. Is that right? Afterwards.
I really can't remember.
Okay. So you don't remember the threat, then the house getting shot?
Yes.
Thank you. That's all I have.
All right. Does the state have anything based on that?
No, Judge.
All right. Thank you. You are excused. You can go ahead and you're free to go. Call your next witness.